Hello, everyone. Welcome to this Grattan Institute speed briefing session on our latest report, which was entitled Short Change, How to Stop the Exploitation of Migrant Workers in Australia. My name is Trent Wiltshire. I'm a Deputy Program Director of Migration and Labour Markets in the Economic Policy team. And joining me today for this speed briefing is Tyler Reysenbach.
Hi, everyone.
So thank you very much for joining us today. This speed briefing will last for about 20 minutes. We'll talk for most of that and then we'll go to some questions. So we've got some that have been pre-submitted, so thank you very much for those people that have pre-submitted questions, but there will be a chance to ask questions during the briefing and we'll try and get to some of those. I think we'll get started. So as mentioned, this report was released last week on migrant worker exploitation. Today we'll be talking about the main finding in terms of the data, and then we'll go through our three sets of recommended reforms. Firstly on visa rules, secondly on strengthening the enforcement regime, and finally on better supporting migrants to pursue underpayment claims. So firstly, talking about exploitation, most of the report deals with underpayment as when we talk about exploitation, but we do also consider broader forms of exploitation. And we take the view that, of course, exploitation is bad. Not only is it bad for migrants themselves who are being underpaid, notwithstanding that some migrant workers may actually be receiving a higher wage than perhaps back at home, we take the view that it's bad probably for most migrant workers, but it's also bad for Australians. It weakens the bargaining power of workers here and undermines the minimum wage, promotes a race to the bottom for employers, so it harms employers that do the right thing. It also harms Australia's ability to attract the best skilled migrants out there. And a key thing as well is that we think if exploitation of migrant workers continues, it will threaten public confidence in Australia's migration program, which has historically been a really well-run program that delivered big benefits to Australia. If exploitation continues, we might undermine that trust. I'll hand over to Tyler now.
Beautiful. Thanks, Trent. So one of the things we tried to do in this report is trying to substantiate how much underpayment there is in Australia. We know from anecdotal evidence, a lot in the media, other surveys done by people that have, of people who have been exploited, we find that, we know that underpayment does exist. The question is ultimately, how much does it? So we looked at two surveys, the Characteristics of Employment Survey and the Employee Earnings and Hours Survey. And I encourage you to read the report if you're interested in the technical aspects of what we did. But basically, using these surveys from the ABS, we find that a large portion of employees in Australia, so this is not just migrants, are underpaid. And that partly formed the basis of some of our recommendations around how we enforce labour laws. So we found that up to 9% of Australians are paid below the minimum wage and up to 4.5% are paid at least $3 below the minimum wage. But at the end of the day, this is a report about migrants. And so what we did is we tried to substantiate how many migrants are underpaid, right? And so what we find is that 16% of recent migrants, so that's migrants who arrived in the last 5 years. It's important to note that these are majority temporary visa holders. So 2/3 of recent migrants are temporary visa holders. We find that 16% of them are paid below the minimum wage. What we also find is that across any measure, from the most egregious underpayment, so $5 below the minimum wage, all the way through to being paid below the minimum wage, recent migrants are twice as likely to be underpaid. So why that is, there's several things at play. So the first thing is that, migrants tend to work in industries where underpayment is more prevalent, right? Accommodation, food services, so hospitality, administrative and support services is contract cleaning, as well as things like agriculture, which is not in this chart. We also know there's a lot of underpayment there. The other element of this is that migrants tend to be younger, and we know that 20 to 30-year-olds are 6 times more likely to be underpaid than 30 to 40-year-olds. But that being said, part of what we did in this report is we tried to control for all these things. And so we asked the question, if you're working in the same job with the same qualifications, the same skill, the same age, same gender, everything, are you more likely to be underpaid if you're a migrant? And what we find is that recent migrants are 40% more likely to be underpaid than long-term residents, those who'd been in Australia for more than 10 years. if they're working the same job, have the same characteristics. So that says that there's something about being a migrant specifically that contributes to your vulnerability. And one of those things is the visa rules of the visas they might be on. And so that will lead us to our first set of reforms around how to reform the visa system. And I'll let Trent talk about that.
Thank you, Tyler. So just to answer people's questions on the go, I actually had to see a couple popped up. So yes, mainly when we talk about underpayment, it is relative to the minimum wage. So you can think of our measure of underpayment as a fairly conservative measure. So not including things like awards, overtime bonuses, superannuation, leave. So this is very much a conservative measure. We think the true extent of exploitation underpayment is probably bigger. And yes, we do include working holiday makers in these calculations, so all temporary visa holders. So firstly, our first set of reforms is about what changes to visa rules can we make to make migrants less vulnerable to exploitation. We think it's one of the key drivers of it, of exploitation. So looking at different categories of temporary visa holders, firstly, temporary skill shortage visa holders. So the middle column there outlines what are the characteristics of the visa that may contribute to exploitation. So firstly, the visa is tied to ongoing employment, means if you don't have a job and you can't get a new sponsor, if your employer is out of business, you lose your job, you have to leave the country. So you're very reliant on your employer. You're sponsored by an employer, so you're limited in terms of being able to switch jobs. You must be the same employer for 3 years to be eligible for permanent residency, which we know a lot of temporary skill shortage visa holders do want. So what we recommend increasing the minimum wage that temporary skill shortage visa holders can earn to $70,000. That has just been done by the government. It's coming in on 1 July. We'd say introduce portability so temporary TSS visa holders can move around. If they're being mistreated, they can move to a new employer and take up a better job. I also think change that requirement to be with the same employer for 3 years to 2 years and with any employer rather than being tied to that particular employer. And then improving the points test, so having another path to permanent residency for high achieving migrants. Looking at working holiday makers. So the key one there, so this is the backpacker visa. It's typically a 12-month visa. To get an extension for another 12 months, typically the person has to do 3 months of specified work, typically in a regional area and typically in agriculture. It's been broadened out a bit during COVID, but it's likely to be narrowed down again. So that requirement to work in certain jobs in certain areas, particularly in remote areas, the evidence shows that that's a key driver of exploitation. So we're saying scrap that so limit the working holiday maker visa to one 12-month visa. The lights have just gone out in my room. Limit it to one 12-month visa with no specified work requirement. So that will take us back into line with what other countries would offer this visa. It's typically these visas are a reciprocal relationship. The visa was brought in as a way of promoting cross-cultural exchange, not about supplying cheap labour. So we think scrapping that will be a key way of reducing exploitation. The PALM visa is about Pacific Australia labour mobility. Again, that's the visa is the person is tied to an employer. So we say bring in portability to give the worker more chance to move around. The government is making some good moves on this. We think they can go further. And for students, a tricky one there is the cap on working hours. So historically, students have been capped at working 40 hours a fortnight during study periods. That was uncapped during COVID. And we did see, we think that uncapping work hours in combination with some other things led to a large run-up or some non-genuine students arriving, potentially undermining and causing some exploitation. That rule's coming back, and so it's going to be capped at 48 hours a fortnight from 1 July, again, during study periods. So there's pros and cons with the working hours cap. The vulnerability there is if a student that's working, they work more than 40 hours a fortnight once, they've breached their visa conditions and are potentially could be deported for breaching their visa conditions once. So an unscrupulous employer could use that to their advantage to try and get the student to work more hours at low rates. So we think, but then again, scrapping that requirement, the cap on working hours potentially leads to non-genuine students coming here to work, and that may have exploitation concerns as well. So we say review this working hours cap as part of a broad review of Australia's higher education system, potentially look at some other countries and what we can learn there. Back to you, Tyler.
Beautiful. Thanks, Trent. So as I mentioned at the start, we found one of the surprising findings from our analysis was that we found a large number of Australian employees are also underpaid, right? And so this points to kind of deficits in the way we enforce our labour laws in Australia for everyone. And so that we spent quite a bit of the report focusing on the work of the Fair Work Ombudsman, who's Australia's Fair Work regulator or workplace regulator. So it's in charge of enforcing the labour laws that are set out in the Fair Work Act, which set out your minimum entitlements, that you must pay the award rate, penalty rates, all that jazz. And so it uses a variety of tools to enforce the law. It uses education, provides education and advice, and tries to help people comply with the law. It has the ability to issue small fines in cases of incorrect record keeping. And it also can order employers to pay back money if they think that they've underpaid their workers. And in the last case, they can take people to court and ask the court to issue penalties, right? And so one thing that's important to think about when we're thinking about what is a good regulator is that you should be making it easy for people who want to comply with the law to comply with the law. We understand that the award system is complex and that sometimes, mistakes do happen. But it does mean that when people don't want to comply with the law, you need to actually make sure you're hitting them with the book. And what we found as part of our analysis is that the Ombudsman is doing the first bit, but they're not actually using all the powers in their tools to, really create a culture of deterrence. Part of that story is because of the framework that government has given them, and part of that story is about kind of the culture and strategy that they adopt. So how this is illustrated, I think, is very obvious. And when you look at different regulators, so the Fair Work Ombudsman last year collected only $4 million in penalties. In most cases, the worst that happens if you underpay your workers is that you have to pay them back the wages that you would have paid them anyway. This is in direct contrast to the ACCC, which got $200 million in penalties, and the ATO, which collected $3 billion in penalties, which really speaks to the idea that, the government is doing more to get its money than it is trying to help other people get their money. So we recommended 3 sets of reforms. So the first one is that you needed to increase the enforcement powers of the Ombudsman so that they're in line with other regulators. This includes being able to issue fines for non-serious breaches, but that are still breaches of the law. It also means increasing the civil penalties quite a lot. So at least 2.5 million or around $2.5 million for normal breaches, or 3 times the underpayment. For cases that are reckless and systematic, taking it to $5 million for corporates, or 5 times the total underpayment. And we also think there should be a criminal penalty introduced in line with the state laws that are currently in place in Victoria and Queensland, with a jail term of 10 years. Now, the criminal penalties are not designed to get everyone. We think it should only be for deliberate cases of underpayment. But the point is to send a strong signal that we're serious about dealing with underpayment. But increasing the penalties means nothing if you don't increase the budget of the Ombudsman and increase the probability that people will actually get caught, right? So what we think is that we noted that the funding per worker for the Ombudsman has dropped since it was established. We think it should have a $60 million boost every year in order to bring it back in line with where it was in 2011, 2012. And then the last recommendation that we have around the Ombudsman is to give it a cultural reset, including giving it a new name that signals its role as a workplace enforcer rather than an ombudsman. And so we suggest calling it the Workplace Rights Authority, as well as pairing this with a capability review to assess whether the ombudsman has the right culture, strategy, and capabilities to be enforcing the law correctly. And with that, I will hand over to Trent to talk about how we can improve the possibility of reclaiming your unpaid wages. Sorry.
Thank you, Tara. So this is the final set of reforms that we recommend. And as Tara said, it's about providing better support to migrant workers who have been underpaid and help them get their wages back. So we know that very few migrant workers who have been underpaid try and get their wages back. So one survey showed only about 9% try and get their wages back if they've been underpaid. So a key part of that is providing support. So migrants can go through the court system, and there's a small planning process that's aimed at being simple, so migrant workers can try and get their wages back. But we know it's actually still quite difficult. So providing support and assistance important. So our first and key recommendation is boosting support, and that's establishing a migrant workers centre in each state. So there's one in Victoria, does a great job of supporting migrant workers with education, advice, support, links to lawyers and things like that to help them report their employers that have treated them badly and to get their wages back. We say more funding for community legal centres, and some of the extra funding that we're devoting to the new Workplace Rights Authority, Tyler just mentioned, devote that to migrant worker support. Secondly, improving migrants' understanding of workplace rights. So better knowledge of workplace rights will help in terms of knowing if you've been underpaid and how to get your wages back. So the Department of Home Affairs does get in touch with visa holders about what they can do and what their workplace rights are. We think they can do more. Another one is providing a real fair work information statement. So that's basically what you get at the moment, which is a very simple version of what you're owed and what your workplace rights are. This provides more detail. So what your work award rates are, what your overtime rates are, things like that. So you can really work out if you're being underpaid. Thirdly, potentially creating a new specialised workplace court or tribunal. So there have been some improvements being made to the small claims process. It's a good step, doesn't go far enough. Potentially, the government could create a tribunal that sits in a fair work system that brings the ability to claim wages and super and make other workplace claims under one simplified process. So currently, if you haven't got paid your super, that's a separate process via the ATO than if you haven't been paid your wages. We think they can go further with the current small claims process as well. So virtual hearings, make it simpler to serve documents. And a final one is expanding the Fair Entitlement Guarantee, which is a government-run basic insurance program that if you're a worker and your employer goes out of business and you're owed wages and leave and different workplace entitlements, you get some of that or most of that back. Currently, migrant workers are excluded from that system. So we think they should be included and get access to that insurance system. Next slide, thanks, Tyler. So we have a few ways of funding this, but I won't go into the details. Please look at the report if you want to go into that. Next one, please, Tyler. And then we have 27 recommendations. So again, please go into the report and take a look at these details. I won't read these all out. I will now get onto some questions because we have got a few and we've got some coming through now. We've also had some pre-submitted. So I'll just start with the pre-submitted ones. From Amy. How do experiences of exploitation differ between migrant men and migrant women? We had a couple along those lines. Tyler, do you want to have a go at that one?
Yeah, absolutely. So, so it's interesting to see that when we ran our analysis looking at different characteristics, once you control for industry and skill, gender doesn't have an effect on whether whether an individual is more likely to be underpaid. But that being said, we know that it doesn't fall evenly across the gender spectrum and other intersectional aspects. So we know that women are far more likely to experience, migrant women are more likely to experience sexual harassment at work. And we also know that migrant men are more likely to experience unsafe working arrangements. So I think it's, and it's unclear how much that is, is there a compounding effect, right? Being a migrant woman as opposed to a woman. But I think, like always, more research and more data to really understand the experiences of different migrants would be valuable in this space.
Yeah, well answered, Tyler. Yeah, so I think that goes to one of the key findings of this report. There's just not enough data and information out there about this really important issue. So that's one of our recommendations as well, that the Workplace Rights Authority does an annual report on the state of migrant worker exploitation, so we have more visibility about what's going on. Another question, and we had a few questions about housing and migrant workers and students as well. So just broadly, we didn't include sort of how, so the questions are about, are migrant workers exploited in the housing system? Are they living in poor quality housing? And I think, media reports show that is the case for students at the moment in our rental crisis. It's definitely a complaint among working holidaymakers and PALM scheme workers, the poor state of housing, particularly in regional areas. So yes, I think it is a problem. We didn't deal with it directly so much on the data front. Again, a lack of data there sort of hinders the ability. It sort of relies on media reports and reporting to really get at that. But I think that is a problem. One thing we've seen recently is that students are coming here facing significantly higher rent than they expected and struggling to pay their bills. Tyler, the Department of Home Affairs what's their wage minute or their recommended cost of living? Was it 19,000, 18,000?
I think it's 21,000.
Yeah.
Yeah.
Okay. Yeah, and it hasn't been updated for a few years. So we're saying that students perhaps receiving misleading advice about the true cost of living in Australia, which may be affecting what they come here and can afford in terms of rents. Just going to a live question now from an anonymous attendee. A bit of talk about the $70,000 TISMIT and how would many employers such as be able to pay a mechanic at this rate or a welder, and also our thoughts about regional employers. So this TISMIT, so the minimum wage that a temporary skill shortage worker can earn, it's rising from $53,900 where it's been stuck at for 10 years. It's rising to $70,000 on 1 July. So a big jump in a short period of time. So we've advocated for that to rise for a while now. This program is aimed at skilled workers. $70,000 is, still a relatively, it's a much higher wage than $53,900, which is well below what a typical full-time worker in Australia earns. So we are very supportive of that increase. We do acknowledge that what the government has done, bringing it in July, is very fast, and that will affect some businesses and visa holders who are paid well below that rate to be able to maybe get another visa. That's acknowledged. And on the regional front, at the moment, some areas can get a lower rate in terms of getting a labour agreement and designated area migration agreement. So there's a bit of discount for regional areas. That I'm not opposed to potentially something like that for true regional areas. We haven't looked into it too much, but yeah, Tyler, any thoughts on the TISMIT question there?
Yeah, I mean, I think we thought about whether we should have like a different TISMIT for the regions or not, because there is a regional wage premium. I think we ended up deciding not to, just because it's really hard to actually force people to stay in the regions from a visa design point of view. So you can say, hey, well, you have to work with this employer, and then you get this wage threshold. But particularly for the permanent program, we know that I think it's like 50% of regional visa holders leave the regions within, I think, 3 years. So it just adds a bit more complexity to the system without actually achieving the goals of trying to help the regions. And so that's where we landed.
Yeah, I think that for temporary, it's, I think, more of a possibility.
That's true.
Given the wage premium in the regional areas. But typically, like at the moment, the way that regions are defined is poorly defined. Often it's just anything but Sydney, Melbourne or Brisbane. Which is not really true regional areas. So I think for true regional areas, there is scope for maybe a bit of a discount, but we haven't actually put the numbers on that or advocated for that just yet. Yeah. Note the time, we've actually gone over our time slightly. So thank you very much, everyone, for attending. Thank you for all the excellent questions. There was a question about, is the briefing pack available? And actually more extended briefing pack is available at grattan.edu.au along with the report and the chart data. So please go there and have a read, and you'll see much more detailed information about this significant problem. For those who want some more content, we also have a webinar on Thursday with our Program Director, Brendan Coates, and we have a great panel there to discuss this. We've got Alan Fells, Joanna Howe and Sharmila Bargan, who's a Community Legal Centre lawyer. So that should be really fascinating. So again, thank you for attending and have a good day.